All right, ladies and gentlemen, we're going to get started. Roll call, please.
Chair Morrell, present. Councilmember Jeruso, present. Councilmember Harris, present. Councilmember King, present. We have a quorum of both committees.
First up, approval of the minutes from the joint committee meeting on March 15th. Moved by Mr. Jeruso, seconded by Mr. King. Please vote your machines.
And
4 yeas, no nays. The minutes are approved.
And Mr. Chair, I just want to let you know, Councilmember Thomas said he's on a panel at Suno right now. We'll be here as soon as he can.
Okay. First up, we have item number 3, which is a resolution regarding the reliability penalty remand. Bazil, can you just go briefly give us an update before we consider the resolution?
Thank you, Mr. Chairman. Bazil Udo with Denton's firm. This resolution is a result of the appeal that Entergy New Orleans brought after the council imposed $1 million fine when the council concluded after an investigation that the reliability performance of the company was not only substandard, but it was imprudent in its handling of that. It was appealed to Civil District Court, and in June, the Civil District Court concluded that the penalty needed further consideration. There's a lot of back and forth between what was said in the hearing and what was said in the ruling, but the judgment of the court was that the penalty part of this should be remanded to the council. The court did not overturn the council's decision that the conduct was imprudent. So this is bringing it back to the council on the remand for proceedings not inconsistent with the court's ruling to look at the penalty aspect again.
Okay, I see no cards. I will move to pass the resolution.
Thank you.
Thank you. Second by Councilmember Harris, please vote your machines.
Councilman, we may have a comment card. Can you?
Oh, well, I hate the comment cards over here. I don't know there's a comment, so. Thank you. Jesse George, come on up. Might just want to sit in the front row. Jesse, can just hop up as we go through the items.
I appreciate that. Thank you, Jesse George, on behalf of the Alliance for Affordable Energy. Just would like to say we appreciate the council's continued efforts to hold Entergy New Orleans accountable for ongoing reliability issues. I would note, as I have at previous meetings, that there have been numerous workday fair weather outages in the first quarter of this calendar year alone. Continuing to hold their feet to the fire, and more importantly, using any penalty money that is imposed to improve these reliability issues and make bills more affordable for ratepayers is of the utmost importance. Thank you so much.
Thank you, Jesse. Moved by myself, second by Councilmember Harris. We have 4 yeas. The resolution's adopted. Next up, we have the resolution regarding gas hedging. Joe, you're here. Can you give a very brief overview of what gas hedging is for those people who are watching virtually just before, and explain what our position will be on the gas hedging as well as how it went last year?
Yeah, this is a resolution to continuing the gas hedging program. This is for natural gas that's used in people's homes. This is not natural gas for electricity use. But the way the program works is Eno enters into some financial hedges in the summertime for 25% of the volume of gas in the wintertime, which essentially stabilizes the gas prices. Now, since these are hedging products, they're meant to stabilize prices and not necessarily make or cost money. But the last 3 seasons, in the 2020-2021 season, it was about a $500,000 cost. In the 2021-2022 season, it was a 1.3 million savings. And in the 2023 2023 season, it was a $3.4 million cost. This year was extraordinarily high with respect to the cost. What we had was the hedges were entered into in the summer when gas was relatively high priced. Gas was high in the summer because it was extremely hot and there were coal shortages, and essentially it drove up the price of gas. So when they were entering into the hedges, gas prices were high. And then the unusually mild winter caused increases in storage. And so when the hedges were coming off, gas had dropped from say $7 or $8 down to $2 to $5. And so this year was an extraordinary with respect to the cost of it, but it did seek to stabilize a portion of the prices going forward. And just for some of the other information, over the past 10 seasons, it's sought to increase prices by about 2%. And prior to this season, the previous 9 seasons, it had an effective 0.7% increase in cost in the winter season. So this is essentially proceeding forward with their hedging program to stabilize gas costs going forward.
Okay, so basically it's the council is prudently betting that gas usage will go up in the winter. So we buy cheaply in the summer when it's not in demand. And 2 out of the 3 last years, we saved tremendous money on it.
One out of 3 last years, you saved a lot of money. This past year was a rather high cost.
Right, but
And
3 years ago, we also saved money.
Yep.
So we saved money 2 out of the last 3 years. Our gas price is extraordinarily high at the moment.
pardon?
Our gas prices right now,
Right now, gas prices have probably hit a relative low that we've seen. It's about two and some change with respect to the price per MCF. So they're really low right now because we're coming out of a mild winter and storage is up and gas has returned to that $2 to $3 range that we like to see, compared to the
Yeah.
$7 it was in the summer.
last summer.
And most importantly, this is it stabilizes the cost going forward. And there's still a great deal of uncertainty in gas. The EIA forecasts that gas in the wintertime for this next heating season is going to be between the $3.60 to $4.24 per MCF range. But if you look at the 95% confidence interval, which is how confident they're in the numbers, it can be as low as $1.13 or go as high as $12.96. And so that's the value of this hedge
Right.
going into the season.
Okay, thank you. I will move. Do we have any cards on this? Okay, I will move.
But there is an online comment.
Okay, online comment.
Gary Meltz, representing Power for Tomorrow. He is a paid representative. He says, as a New Orleans resident and the executive director of Power for Tomorrow, a group that advocates for sensible regulation of electric utilities, I urge the council to allow Entergy New Orleans to continue its practice of hedging natural gas purchases, especially as we look to the upcoming 2023-2024 heating season. Please keep in mind, natural gas prices are lower today than in recent months. Locking those prices in could result in cost savings for customers later this year and into next year. And even if the natural gas hedges don't result in cost savings for ratepayers, they will help ensure stable pricing on customers' energy bills. With this in mind, I urge the City Council to review our report we released last year, which found clear evidence that as natural gas prices skyrocketed due to market constraints caused by the war in Ukraine, customers living in restructured states lacking the regulatory oversight which allowed utilities to lock in low natural gas prices were left vulnerable to higher market rates for natural gas and saw their power bills skyrocket. Thank you, Gary Meltz.
Thank you. I will move. Can I get a second? Second by Councilmember Jeruso. Please vote your machines. 4 yeas, no nays. It is adopted. Motion number 5 is the consideration of a motion to increase the budget for our paid consultants due to the FERC litigation. Could we have Clint, could you go down the table and kind of explain where we're at? on the litigation.
Thank you, Chair Morrell. My name's Clint Vince, and I chair Denton's energy practice. And I'm joined by my law partner, Presley Reed. I'll give a very quick overview of the cases that we're handling at FERC right now, including a case that we just won in December that we feel has a potential value of $190 million for New Orleans ratepayers. As you are aware, but many New Orleanians are not aware, is that most of your big dollar cases and wins for ratepayers are handled at the Federal Energy Regulatory Commission in Washington, D.C. A good example of that is that you funded your energy efficiency programs in the early days, really with money from those wins. The key initial case, I'll talk about 5 groupings of cases. We have more than a dozen proceedings at the Federal Commission. We have also been teaming with the Louisiana Commission and the Arkansas Commission on all of these cases, which has helped us share legal costs and also present a united front for our respective ratepayers. The lawsuits that we've been involved in really have a tremendous potential impact on savings for ratepayers. The bottom line is that the potential savings are massive. The case we won in December, we feel will result in $190 million in savings. Entergy has already paid $34 million, but they're contesting what we think is a very clear order. So we have moved with the other 2 commissions for enforcement of the federal order, and we should have a ruling within the next month or 2 clarifying our position on that. The other point I should make is that the council has been winning a number of cases before the administrative law judges. Those are the cases that assemble the evidence, give a ruling, and then that goes up to the commission for final decision. Entergy has not won any of those cases. The second major complaint that the council has launched involves the Grand Gulf Prudence case. This case we feel has a value of $170 million for ratepayers if we're successful on our litigation position. The key takeaway for the Grand Gulf complaint is that for a number of critical years, Entergy's output from Grand Gulf was only 53%, whereas the industry norm, including nuclear plants with the exact same technology, was 93%. So 53% for Entergy, 93% for the rest of the country. Entergy's safety record is also one of the worst in the country among nuclear plants for the Grand Gulf unit. The 2 other commissions and New Orleans jointly retained a nuclear expert so that we could share those costs. The expert filed a report indicating that Entergy's operation of the plant was grossly imprudent. And so that is what we've based our complaint on. The third grouping of cases involves at the Federal Commission involves a host of tariff violations. Those cases have a potential saving for ratepayers in the amount of $37 million. And Entergy has already settled several preliminary issues, which will bring $6 million in the short term to New Orleans ratepayers. The fourth grouping of cases involve a win by the council at the administrative law judge level. These cases involve return on equity and capital structure. And we believe those cases have a value for ratepayers of $42 million. If the favorable decision we've received from the administrative law judge is accepted by the full commission. And finally, we have about a half dozen other cases at the commission. The dollar value on those is not as great as the ones I've just mentioned, but they are still significant proceedings. So to sum up, if the council continues on its current winning streak at the Federal Energy Regulatory Commission, we have the potential to bring home for ratepayers $190 million in the ADIT case, $170 million in the Grand Gulf Prudence case, $37 million in the omnibus tariff case, and $42 million in the return on equity case, where we have already won at the initial decision level. So we can never guarantee the outcome of litigation, but we feel optimistic given the number of wins we've had before administrative law judges in the preliminary decisions. With that, I'll turn it over to Presley to give a little bit more detail on the content of each of the cases.
Generally speaking, good morning, council members. My name is Presley Reed, and I'm a partner at the Denton's firm. We've got approximately 17 active cases at FERC. Clint has sort of given you an overview of most of those cases. I think he's also giving you sort of a broad perspective of understanding what those cases are about. But I would sort of group them into four categories. One's dealing with rate issues like the return on equity and capital structure case, tax issues that involve accumulated deferred income taxes and net operating losses carryover, which are just truly scintillating issues that will put you to sleep in about 3 minutes, but they affect rates and it affects the cost that ultimately fall on ratepayers. We've got tariff issues where we feel that Entergy has not followed all of the rules of the tariff that are in place. And obviously the prudence case that we spoke about related to Grand Gulf and its operations. I think that the most significant aspect of the fact is the cases that Clint mentioned, approximately 12 of those cases are in settlement. And when I say settlement, you need to understand when a case is filed at FERC and FERC decides we're going to allow this case to go forward, they always send it into what they call settlement procedures. Those settlement procedures means that we must sit down with the other parties and are working with a settlement judge that tries to broker a settlement. So even though we're in settlement, it is very likely if we do not reach some kind of accord that we will be in litigation and those cases will move forward. You know, Clinton noted the omnibus tariff case that was just litigated last year. That case was intended to last approximately 2 weeks. It started in September and it ended in December. Entergy put forward 19 witnesses. It was long drawn out, and I expect the same type of complexity and demands with the Grand Gulf Prudence case. And I also do not expect any type of settlement out of that case. I think currently the parties are too far apart, but I can answer any of the questions you might have on any of these cases. That's it.
Thank you for that. I do want to make one note, and it's something we talked about previously, and it's kind of a interesting wrinkle that I'm sure many people are not aware of. So the council pays our legal advisors their rates, and Entergy reimburses us for those costs as part of the normal process. What is not known is Entergy is also reimbursed for the rates it pays to its lawyers in the FERC litigation. And this has become increasingly problematic because, as we discussed previously, Clint, there are a tremendous amount of delay tactics that are being utilized by Entergy to drag out litigation and to increase the cost of litigation.
Absolutely.
So the challenge is whereas on our end, we very competently with Kiro's office publicly manage the budget of our legal advisors, we do not manage the budget of Entergy and its legal advisors, and whatever they charge for their legal fees goes right on the backs of ratepayers. It's something that I don't think the public is aware of. It's actually kind of dastardly that there's not kind of like a public disclosure of how much they're paying their lawyers, because our goal is try to settle this litigation as quickly as possible in a fair way for our constituents and for our ratepayers. But when you're dealing with, as we previously discussed, how long was our trial supposed to take when we went into it last year? The one that went through December. What was the original estimate?
2 weeks.
2 weeks. So we had a FERC related litigation hearing. It's supposed to be 2 weeks. It began when?
September,
In September, and ended in when?
December 16th.
December 16th. So the reason why we're here today is because we set a prudent budget based upon it going 2 weeks. It went several months, whereas our ratepayers are taking it on the chin because Entergy is just passing the cost of delaying the FERC litigation to pay what they owe. And we as ratepayers are paying them as they delay us actually getting this resolved. I've begun communications with Congressman Carter. I think this is something that has to be addressed at the federal level. I think that it is unconscionable that utilities can simply pass the costs on to ratepayers unfettered. And I think there needs to be a more public accounting of how much money they're spending on lawyers, as well as cost controls that they cannot just delay. I mean, this FERC litigation has been going on for years because they keep losing and don't want to pay. Am I incorrect?
Absolutely.
Yeah. So, I mean, they could just pay what they owe because we keep winning. But as long as they're getting free lawyers paid for by ratepayers, there's no incentive to do so. So it's something I'm going to work with our legal team. I'm going to work with our congressman, work with LPC, and work with the other congressmen as well as Arkansas, and see if we can come up with a solution on the federal level, because I'm sure we're not the only state or only jurisdiction that's dealing with this vicious loop of how these bills are paid for legal work. So I appreciate the work y'all are doing. I have all faith that we are going to get significant judgments in our favor for the neglect, especially and most egregiously on Grand Gulf. Grand Gulf is just an ongoing train wreck. And even as we're in FERC litigation, as you know, last year repeatedly, Grand Gulf kept failing over and over again. And that's not even from litigation we're in. This is old stuff we're litigating. So we don't even know. I'm sure you guys are working with Joe to look at what we're owed on Grand Gulf repeatedly failing last year, but that's new litigation we have to now do for ratepayers. So appreciate y'all being here. Thank you. Jesse, you have any comments? You usually have comments, so you don't have to. I want to make sure. I know you've got your little guy with you, so I want to make sure you weren't missing a moment.
No, I appreciate that. Jesse George, once again, on behalf of the Alliance for Affordable Energy. And once again, we support the council's dogged efforts to get what's coming to ratepayers. These reliability issues at Grand Gulf have cost us hundreds of millions of dollars over the years. So this small increase in budget, I think, is well worth it.
Thank you. All right. I see no other comments. Any online comments? Okay, hearing none, I will move that we adopt the resolution. We'll adopt the motion, sorry. Seconded by Councilmember King. Please vote your machines. 4 yeas, no nays. The motion's adopted. Last, we have the resolution, and I'll handle this one, Aaron. This is simply appointing former judge and soon to be current judge Calvin Johnson as a hearing officer for the docket UD 2001. I will move on that resolution. Can I get a second? Second by Councilmember Jeruso. Please vote your machines. 4 yeas, no nays. I assume we had no cards on that one. All right. Next up, number 7, the Sewage and Water Board billing ordinance. I can handle this one. Simply put, as y'all know, last year, after some legislative activity, we were able as a council to obtain greater control and input on the billing structure of the Sewage and Water Board of New Orleans. This ordinance is actually an effort to amend some of the existing procedures we passed last year to clean up some things we saw that were not working as intended, as well as some loopholes. In short, it requires council decisions on appeals to be transmitted to Sewage and Water Board within 15 days. It changes the implementation requirement from after the administrative hearing to no later than second billing cycle after the date of the administrative hearing judgment, and changes the number of days Sewage and Water must complete repairs, the number of days which Sewage and Water Board must notify customers of the estimated date in which repairs will be complete from 60 days of the administrative hearing to within 60 days of the administrative judgment date. The Sewage and Water Board Advisory Committee recommended approval. There are some changes to the amendment from when it left committee. They are substantive but technical to make sure that it comports to the existing ordinance structure. They do not change any of the actual substance and the process from the original ordinance. And we proposed to amend the deadline for appeals to response Sewage and Water Board delayed till May 26, 2023 to allow about a month for adoption of the ordinance. And the ordinance and amendment are on the regular agenda for our meeting next week. Are there any, Mr. George, come on up. Do you have any other cards? Okay.
Yes, thank you, Jesse George, once again, on behalf of the Alliance for Affordable Energy. While we're certainly supportive of creating a process to address these bill dispute issues, and we understand that the council receives a large volume of complaints regarding Sewage and Water Board bill disputes, we do have some concern about this process being established within the Council Utility Regulatory Office, for the simple fact that city code already requires that office to handle bill dispute appeals for Entergy customers, a part of the council's ratepayer Bill of Rights that was passed years ago. Unfortunately, that process has never actually been established at CURO. The form that's supposed to be available to the public to appeal those bill disputes is not available. It's never been created. And so our concern is that we're creating a process that the Council Utility Regulatory Office is not equipped to handle in terms of personnel and resources, because the already existing burden that they have to handle these Entergy bill disputes is not being met. And so to then, place this enormous additional burden onto that office without the appropriate personnel, our fear is that we're creating a process that will lead people to a dead end. And so we just want to raise that to your awareness and make sure that you are, aware of our concerns and the need for this office to have the support and the personnel to actually make this process successful. Thank you.
Thank you. I will, if there's no further comment, no online comment. Okay, I'll move that we adopt the ordinance. Second by Councilmember Harris, please vote your machines. 5 yeas, no nays. The ordinance is adopted. Mr. Thomas, you have this last one, number 8.
Yeah, number 8 is just under state statute 33-4091 is at a reporting period. We know that Sewage and Water Board has not always honored that reporting. This ordinance is just to make sure that they do. Any other points, comments, any online comments? With that, I'll move adoption. Seconded by Councilmember Morrell. Vote your machines, please. 5 yeas, no nays. It's approved. Thank you.
All right, last time on the agenda, we were a presentation regarding the 5G enforcement update.
Good morning, Council President Morrell, council members. Sarah McLaughlin Porteous. I am the Chief of Staff for Infrastructure and Operations and Acting Director for the Department of Public Works.
Brian Block, I'm the Director of the Bucharest Commission and the Historic District Landmarks Commission.
We appreciate the opportunity to be here this morning to provide an update on the process for issuing our small cell installation permits and then the ongoing audit that we have been conducting on permits that were issued to date. So this morning, I'm going to provide a brief overview of the small cell permit process. I'm going to talk about DPW's scope for review and coordination with VC and HDLC prior to issuing those permits, and then we'll provide an update on the 5G pole installation audit. Okay. Sorry about that. Okay, so since the last presentation in December, DPW has continued to grow our traffic engineering division. So Alfred Terry, he's overseen by our interim chief traffic engineer, Kevin Jawar. He's an engineer intern in our DPW traffic division, and he is now the point person who's designated to review small cell installation permit applications to ensure that the proposed infrastructure is in compliance with the code and the design guidelines that were previously promulgated by council. In terms of our process, I have reviewed this before. I think it's important to go through it once again, but I'll try to do that relatively quickly, just as a reminder. So the first step, a telecommunications provider applies for a small cell permit installation. Their submittal includes a site plan showing the specific location of the installation. That includes overhead pictures, on the ground view pictures. It includes the longitude and latitude coordinates. It includes the scope of work, whether it's a new pole, a replacement of a streetlight pole, the co-location on an existing pole, et cetera, and then the actual design itself. And it is the telecom that's responsible to notify all property owners within 300 feet of the proposed location when the permit application process is started. And then if any resident has an issue or complaint, they work directly with the telecom to try to find a resolution. The next step, the departmental reviews begin. We check the permits for all the required documentation. DPW reviews the location within the public right-of-way. That could also include a review by VCC or HDLC and possibly Parks and Parkways, depending on if the installation would be within a historic district or in the proximity of a city tree. VCC and HDLC would consider the aesthetic design of the installation to conform to the character of the area and their own design criteria, and would consider other criteria such as location to minimize negative impacts to the area. The next step includes the fees. Fees would be added based on the scope and location of the work. They range from $100 to $2,500. And once the telecom pays, the small cell installation permit would be issued. And this permit serves as the approval for the location only and the above surface installation. It does not cover the subsurface utility work necessary to bring the infrastructure into service. So once that part of the process is completed, once the location is approved, the telecom would have to apply for the separate street cut permit. It's also known as a utility or service cut permit to facilitate the installation of any foundational work that needs to happen, as well as to be able to run the subsurface conduit to be able to power the infrastructure. This is also reviewed by Sewage and Water Board to check for any conflicts with their subsurface utilities, and then DPW for traffic impacts and pavement restoration. And then finally, once both the small cell installation permit and street cut permits are issued, the telecom can begin its construction. Okay, so quick review of DPW's scope for small cell permits. We are checking to ensure that the poles are at least 18 inches from the curb, that a minimum of 4-foot clearance width on the sidewalk remains accessible for pedestrian access, that there are no sightline issues created by the installation, that any modification to or replacement of a streetlight pole will maintain the appropriate lighting levels, as well as a new small installation will be at least 300 feet away from each other or co-located on the same pole. So for conflicts within HDLC or VCC areas, DPW will advise those historic entities to take the lead on coordinating acceptable alternative locations or co-locations with the telecom and or adjudicating when an appropriate exception would be. For sites outside of the historic district, we will address when those come up, likely by involving the relevant council district staff and providing input within the specific district on the proposed location. I wanted to share this resource with you because this is a change that we have made since the last presentation in December. One of the challenges that we had previously in approving these permits is that in ensuring the 300 feet of separation is that we did not have a map in Llama actually showing the existing and proposed small cell locations. So this map is showing exactly that. This is sort of a snapshot of what it looks like in the French Quarter. So this data, as well as the information gathered through the permitting system, is being used by DPW and VCC to ensure that future requests don't cause an oversaturation in a particular area, and also can be used as a tool to suggest co-location if the poles are within 300 feet of one another. Okay, so we began our audit earlier this year of a total of 663 permits that have been issued in New Orleans for 5G pole installations. And what we have found is that there are about 200 pairs in violation of the 300-foot rule. And the way that we did this, we basically pulled the coordinates, as those are a requirement for the telecom to submit when they're applying for the permit. And from that data, we were able to determine that there were 200 pairs in violation of the 300-foot rule. And then in the French Quarter, of the 663 total permits, 255 were issued, and we found that 145 pairs are in violation of the 300-foot rule. And Brian Block and the VCC conducted a complete survey of the entire French Quarter, and we were very appreciative of their support in doing this audit. Some of the things they found: a number of locations where small cell poles were installed without the proper permits. Some examples of that, and Brian may want to go into further detail, but 804 Governor Nichols, 610 Ursuline, 740 St. Louis. They also found a number of permits that have expired and should not be renewed as they deviate from the approved small cell guidelines at 495 Barracks, 1250 Bourbon, 1038 Ursuline, 585 Ursuline, 670 St. Philip, and 971 Charters. Do you want to add anything to that?
No, but we did conduct a field survey on foot where we could, visually identify each location. And we were able to document those that Sarah remarked on, and we're able to take this information back to the office and revise our review protocols to avoid this going forward. And we can discuss that if you'd like to.
And then just an update on the 4 locations that were requested by council for us to look into. So these included site visits, not just review of all the information that was submitted online with the original application. 1025 Orleans, the actual address of the small cell pole is at 1051 Orleans. This was a Verizon permit that was issued in August of 2021. We found 2 devices at this location. So 1051 Orleans has an issued small cell installation permit, but the associated street cut permit was not issued and remains in pending status. So next steps on this, DPW will continue to investigate further in coordination with BCC to determine next steps and to either allow the installation to stay after proper permitting or to require resubmittal for a new review as appropriate. And then 1028 St. Anne has an issued small cell installation permit as well, but no associated street cut permit to the same location. Same thing, we are going to continue to investigate to determine if we'll follow the same process as 1051 Orleans. For both Clara and Jefferson, so that's 5121 Clara Street, small cell installation permits have been issued, but the infrastructure has not yet been installed. So DPW will continue to work in coordination with the law department to confirm options to address. The St. Philip, so the 500 block of St. Philip site for this was Verizon and Toro Blanco permits issued in August of 2021. 3 devices were found on this block and at 580 St. Philip, 550 St. Philip, and 995 Decatur. After consulting with law, DPW will work with the telecoms to see if they're willing to co-locate to reduce the number of poles in this area. So in terms of our next step, obviously, we're pretty early on into the audit. So we're going to continue an audit of the locations with the pairs that are in violation of the 300-foot rule. And we're working with law to try to determine what our options are to ensure that the proper procedure is followed for resolving these issues with any installations that were not installed with all the proper permits. both small cell and street cut, or did not follow all of the permit requirements. We need to, as part of this process, we need to identify older locations with issued permits where installations have not yet occurred. Close out any of those that have exceeded the maximum permitted timeline for installation. We think there are a number of those in the queue, and require resubmittal to those telecoms to ensure that they meet all of the current guidelines. As I mentioned, we need to review all of those pending applications. I believe there are just north of 475 that are pending, to ensure that everything from now onward is in compliance with the current guidelines. Any found to be within 300 feet of another will be evaluated by VCC, HDLC, or the relevant council district staff if within an area outside of a historic.
Sarah, can I interrupt you for 1 second?
Absolutely.
Sorry.
I'm just about finished.
Okay, from my understanding, in order to install these poles next to a residential structure in the View Correa requires an exception. Am I correct? Mr. Block?
I'm not sure what an exception.
Council member, it's the code section states that locations requiring an exception include wireless facilities and public rights of way of local streets within residential zones.
Okay, sorry. So have we been able to detail whether or not these exceptions were sought to begin with?
That's not part of my review. I'm not. sure
Okay.
of that.
Is there any way, Sarah, you can look into that? Because I'm basically from our purposes, and because you're stepping into the mess that was
Yes.
before you got here.
Yeah.
I am so happy y'all are addressing it now, but I really want to be able to have the receipts to show that, because obviously we're going to get pushback from the telecom groups who are going to say, well, we thought we were doing what was allowed and we don't want to pay for the relocation of poles. And I think the more we can show the receipts of under every variation of the law, you were not in compliance. And had you done any due diligence, you would have seen you were not in compliance. Showing that they did not seek or receive the exceptions required by law would be helpful.
Okay.
So when they come back and say, I don't want to pay to relocate that pole, we can say, no. You've done these poles before. You've done this work before. If all the boxes weren't checked, it's as much your fault as it is the city's fault, because obviously we want to mitigate bearing the cost of relocating the poles.
I'm happy to look into it.
Okay, thank you.
Obviously, our focus has been on making sure that the process going forward
Yeah.
is as it should be, and that, exceptions are not granted, but I'm happy to look into that.
Thank you.
That I pretty much concluded the presentation. The last bullet I had on there was just that we're utilizing the new mapping structure, which is really going to make it a lot easier for both DPW and VCC in our reviews to ensure that we don't have additional poles that are within 300 feet of one another. Happy to answer any additional questions.
The board is clear. Do we have any online comments? Okay, we do not. Sorry,
Just
King.
This is a comment. If we could just be conscious of those curb cuts, because a lot of times we've seen through our walks in the quarter that the company, or that, I guess maybe DPW or Public Works, or the company that does the curb cuts, when they go to fix them, it's pretty bad work. And that leads to the already narrow sidewalks becoming narrower and unlevel. So we just stay on top of that and make sure those curb cuts are done properly.
Yeah, understood. I think related to these, we do go out, before they're energized, we do go out if there's a street cut permit to make sure that it's been done in accordance with DPW specifications, but there's a lot of work happening out by other utilities outside of these where those issues may be popping up. So we will look into it.
Well, thank you.
Thank you.
Thank you. Board's clear. Thank you for your time here being today. Aaron, do we need a motion to put all those items on consent?
So everything except for the ordinance and its amendment are eligible for the consent agenda.
Okay, then do we have to move to the consent agenda, or is it automatic?
You can just tell me to.
Okay, put all that on the consent agenda. That is allowed to be on the consent agenda, except for billing because we had amendments. All right. With that, I move we adjourn. Can I get a second? Second by Councilmember Harris. Any objection? Hearing none, we're adjourned. Thank you.